All right. Hello, hello. Let me see if I can get that focus in where it's supposed to be here. There we go. I'm here. Okay. I don't know why it's doing that today, but it is. Anyway, hello, everybody, and welcome to another episode of Asked and Answered Live. I'm Gordon Firemark. I am an entertainment, media, and business attorney, focusing my energy on largely, but not entirely, on the digital media space, also working in film and television and live theater. And I am going to be answering some questions that have come in. But before I do, well, I won't say before I do that. And that one of the questions that I get quite a lot has to do with insurance. And I want to address that because today I decided to do kind of a deep dive on the question. Usually it's a podcaster, sometimes a YouTuber who comes and who asks me, "Hey, what kind of insurance do I need in my enterprise as a content creator?" So, imagine you're creating a YouTube series or your podcast is hitting the top of the charts and something bad happens. Maybe your equipment gets stolen or you have a flood or you get hit with a lawsuit. How are you going to address and handle those kinds of things? So we're going to dive into that a little bit here. I'm going to probably do an episode on this as well. But so we're going to talk about insurance. I've got some questions about using songs but changing the lyrics. A couple of those questions just came in the recent few days. And also going to talk about using folk songs by particular artists, and we'll talk about public domain and copyright term and the multiple copyrights that are involved there. But if you have any other questions, I'd love to have them. So hit me with them live here in the comments or the chat here, and I will be delighted to pop in my answers and just say hello, so I know you're here and watching too. I'd love to chat. Danny is here. Nice to see you. And I think you were one of the people who asked one of the questions, but in order to not throw you under a bus, I'm going to not describe which question that is, Danny. So we'll get there. All right, let's talk about insurance and all that. Hey, David, nice to see you. Thank you for being here with me. If you have a question, go ahead and drop it in the comments, and I'll try to get to it before I wrap things up. I don't have any particular time frame, so I just sort of go until we're done, or maybe it just gets too long and I start to fall apart. We'll see what happens. Anyway, thanks for being here. So let me start off talking about the insurance question. What kind of insurance do you maybe need in your content creation business? We're not just talking about the big company kind of insurance, but every podcaster, every YouTuber, every blogger ought to at least consider some of these things, because the reality is that content creation is a kind of a business, and like any business, it has risks. And insurance is one of the great ways to mitigate those risks and protect yourself. I also strongly recommend, obviously, my 4 pillars or the 4 foundational things, which is have a good business entity structure in place, have good team arrangements and the strategy and structure there as well, so you know who everybody is and what they're entitled to and who owns what and those kinds of things. Knowing about intellectual property, respecting other people's intellectual property, and protecting your own. That's copyrights, trademarks, and sometimes patents and trade secrets as well. And of course, then working with good, solid contracts to manage the relationships with your team and with your sponsors and customers and clients and things. But insurance is sort of the 5th leg of that table, I guess you could say, the 5th pillar. So let's kick this off with a conversation about the kinds of insurance policies that might be applied to a content business. First off, property and contents insurance. This might not be something you've given a lot of thought to, especially if you do your production in a home-based studio. But if it's a business-related thing, you might want to double check your policy and make sure that you're covered against property and contents insurance. Now, look, if you own a store and someone broke in and trashed the place, or you had a flood and you lost all your inventory, you would want some insurance to cover that. And the same is true if you're recording in a home office or a studio or a rented co-working space. You've got an investment in your equipment, and in the other things that you use to make your content. And it is only right that you think about how to protect yourself in case something bad happens to that. This is insurance that covers your physical assets, your recording equipment, furniture, and that kind of thing. And be aware, your homeowner's policy might cover you for personal stuff, but if it's being used for business, you probably need a separate rider, a business rider or something, a home-based business rider. It'll cover things that live in the house, but probably not portable kind of stuff or technical stuff that you're going to take on the road with you if you go other places. So just be sure you review your policy and consider adding some extra coverage for that. Loss of income is another casualty loss that you might want to think about. If your livelihood depends on you putting out the content, and for a lot of us that is pretty important, and you got to be consistent getting your content out there and so on. If you lose your stuff, if you lose that equipment, you might lose out on income. You might lose out on the opportunity to make your income. You might lose revenue, those kinds of things. So this kind of insurance, loss of income or income replacement, sometimes it's called, can be important. This can also apply to a data loss. If you were in the middle of making a film or something like that and the drives got corrupted and the film's gone, well, now you've spent a ton of money on something and had this loss that you are not going to be able to use. And so that's another kind of concern to have. Loss of income insurance also acts as a safety net if you had to cancel a job because of missing equipment or something. Hey, Genesis, thanks for being here. And Danny says I'm free to talk about the details of things. So we'll see. I'm more comfortable not being too specific. So anyway, another kind of insurance, general liability insurance. This is the kind of stuff that you worry about if somebody were to slip and fall while they're at your studio, or trip over a cord or a cable while you're out on location or something like that. This is the protection against personal injury, property damage, kinds of claims that might come up related to the making of the content and so on. If a guest comes to your house or your studio to be interviewed and something falls on them and they are injured, those kinds of things. Or if you damage property while you're filming on, years ago I was working on a film project and the camera crane swung out and actually just completely knocked over. It damaged the camera, but it knocked over the kids' treehouse on the other side of the fence from the property that was the location. So the neighbor's property, this treehouse was completely demolished by the camera crane swinging far too fast, and that was the kind of thing where the insurance claim pays it and takes care of it. So you really want to consider carrying that kind of coverage if the risks and the nature of your projects justifies it. The fourth kind of insurance we should talk about is what we call professional liability insurance, malpractice insurance in the professional world, but this is also sometimes called errors and omissions insurance. And I've actually sometimes mistakenly told folks in this world what you need is media errors and omissions insurance. And that's actually two different kinds of insurance in the way the insurance companies talk about it. So the E&O, the errors and omissions, is a shield against claims that you didn't do your job right, that you didn't deliver the content or the services that were required or something like that. So let's say you've got a brand deal and you're supposed to create some sponsored content, and then for whatever reason that doesn't happen. They come at you and say you blew it, you copied stuff from other people, whatever. Defending yourself against that could be a real problem. And so having this kind of professional risk liability insurance will cover the legal fees and the potential damages if you are found to be at fault or something like that. And then there's the fifth, media liability insurance. And this is the one that I want you to really think about as a creator, because look, it's easy to accidentally infringe a copyright or say something that hurts somebody's reputation or reveal a bit of private information or something like that. So what this is it's it's a kind of insurance for that's like general liability and professional liability because it covers the injuries to others as a result of your content. But this is specially created policies for those of us in the content creation space. It covers you against claims that are related to the content that you're making: defamation, invasion of privacy, copyright infringement, and other media related kinds of risks. And in the world we're living in today, one comment or one little clip of footage that could lead to the legal action that you worry about. So you want to think hard about this. And there are now a handful of carriers. Just today in this deep dive I discovered what, 5 or 6 different carriers. I'll list them. Not that I'm recommending any of them, but you might want to check into Axis, AXIS, Hiscox, which is HISCOX. There's an outfit called GoSuperscript.com that has some, you can get a quote online. Insurion, INSUREON. The Hartford seems to have policies that do this, and GFC is another one. So there's a bunch of different resources. And if you just Google media liability insurance, I think you'll find them and be able to track it down. My understanding is that it is somewhat expensive, but one of the quotes I saw today was just like $70 a month or something like that. Of course, that's going to depend on how much content you're generating and how often, and the very nature of it. Are you doing investigative reporting or true crime, or are you doing comedy? That will impact the nature of the risk involved. But let's say you have a guest on your show, and then they say something that they shouldn't, that hurts somebody's reputation. Or they come at you later and say, you twisted my words and you edited me out of context and things like that. And so they claim something that. Or maybe you use a clip of music that you thought was royalty free, but it turns out it wasn't. Maybe you had a single use license and you used it more than once or something like that. Most of the time those things get resolved, reasonably amicably with people. But these kinds of things can lead to problems. And in fact, one of the questions I'm going to get into tonight talks about just exactly one of those kinds of scenarios. So 5 different types of insurance to think about: property and contents, loss of income, general liability, professional liability, and media liability. You may or may not need all of these, or you may not need any of them. Cost benefit analysis. Oh, one other kind of insurance that we haven't talked about is if you have people working for you, with you, who are going to look to the outside world like employees, you're going to need worker compensation insurance. And if you're going to be driving around, or they're going to be driving around on business, then you may also need business motor vehicle coverage, whether it's a company-owned vehicle or a personally operated vehicle. You may need some special coverage for that if you're using yours or other people's vehicles in your business. So, think about insurance as an investment in protection. It could cost you something, of course. It's not always going to be cheap, but one lawsuit is enough to bankrupt most individuals and even most small companies. And so, incurring that cost and being prepared and budgeting for it, frankly, is probably a worthwhile endeavor. Talk to an insurance professional. Find a broker and talk to them about it, and lay out for them what you do and ask them to help you analyze the nature of things. All right, so let me get to another one of the questions that I saw today. This one, this is about a YouTube takedown over the use of some music. This person who wrote in said, YouTube took down my video in which I changed the lyrics to a famous song. I'll tell you, it's Lee Greenwood's Proud to be an American. And the person who wrote the question in had changed the lyrics to flip the narrative to a progressive, a Kamala Harris narrative, essentially. I don't want to get too far into the politics of it all, but YouTube took it down. Apparently, Greenwood's team reached out to YouTube and said, hey, that's not okay. And look, it's the same musical composition. It's the same melody line in the lyric, but the words have been changed to a different set of meanings. And actually, Greenwood's song is not a political song per se. It's been sort of co-opted and adopted by the GOP, but I mean, the message that's in it isn't really one way or the other. I don't listen to the song often enough because it's just not my thing. But anyway, so the question is, isn't that kind of an edge case why it was taken down? And normally when a takedown happens, the person who posted the material has an opportunity, a short window of time, to respond and say, no, it's fair use, or here's why it's okay. Maybe you had permission or a license, or maybe what you're doing is a parody or something like that. And typically what happens then is YouTube will put it back up. Now, in this particular case, the person who wrote in, we got to go through this analysis a little bit, because you've taken essentially the whole song and changed the words to alter the meaning. And in the fair use analysis, we have to first ask, is it a parody? If it's a parody, we got a shortcut to a finding of fair use. But a parody has to be making fun of the original song rather than a message about something else in society. So using humor and levity to make fun of the original, or point out, criticize, judge the original thing, that's what is a parody. And I did hear the video in question. I followed the link that I was sent, and I don't think it's a parody, bottom line. I think it is satire, but with satire, we don't get the shortcut. We have to go through the full 4-factor analysis for fair use. And in this case, I'm just not sure it really is fair use. The first factor is the purpose and character of the allegedly infringing use. And here we have, it's satire. It's not even satire. It's just a political commentary. It's not about the song. It's about the world we live in, and to a certain extent, the politicization of the song, I guess. But satire, maybe. I'd say that's right on the middle. That one's on the bubble. The second factor is the nature of the original work. And this ties into, are we somehow transforming that nature? The original work is a piece of music. It's an entertainment thing. And the new work is also a form of music, entertainment. There isn't a lot of difference or transformation there. So that weighs, I think, against fair use pretty strongly. The next factor is the one that is a hard one here, and that is that it's the amount and substantiality of the portion of the original work that was taken to create the new work. And that was 100%, almost 100%. I mean, you could divide the lyrics and the music into halves, but then the lyric follows a melody, so that's still built in there. So I'd say 75% to 100% of the work has been copied. And so I think that one weighs pretty heavily against a finding of fair use. And then the fourth factor is the market impact, the impact on the market for, or the value of, the original as a result of this copying. And on this one, is there a real impact on the market for Lee Greenwood's song and licensing of the music and things like that? Maybe. I think this one is sort of neutral, or maybe even a little bit on the side of fair use. But when we weigh all 4 of these factors, I think we're tipping in the direction of copyright infringement. And so the work stays down. Now, if you're listening and you're the person who brought that question in, you can challenge the takedown. You can file your counter notification saying it's fair use, it's satirical, it's transformative. You can say all those things, and YouTube will probably put your video back up. I think they give the other side a chance to go. You go back and forth a couple times with YouTube. That's not required by the DMCA, but once they put it back up, then the other side has some time to file a lawsuit against. I think it's within 14 days they have to sue you. So if they want to sue or something like that. So that's what you're up against. You could get sued for copyright infringement, and then YouTube just stands back and says, "Okay, you guys figure it out." And while the lawsuit is pending, I think they probably take it down again. So that's sort of where you are. If it was me, look, I was amused and entertained by it, but I would not probably challenge that. You don't need the copyright strike, and the person who sent it is a comedian, um, you know, needs the YouTube channel to promote their activities and keep things out. So I would, in this instance, err on the side of caution. But maybe you use it as a springboard to make some other content where you talk about the ridiculousness of this, or you call out YouTube and these musicians and the nature of politics and how it's using music. There's a lot of stuff going on in the music and politics arena right now. We know Celine Dion has objected to the Trump campaign using her song in their stuff, and somebody else recently also objected to, I think it was the Trump campaign's use of a piece of music. But it's happening on both sides of this. So it may be something worth talking about, and maybe even setting up a little bit of a stand-up routine about, or something like that. So if that's you, I hope you take that to heart and let me know. Send me stuff, send me links if you decide to do any of that. So that's good. Another question that had also come in was the same kind of thing, a particular song with new lyrics. Is it fair use, parody, or satire? And in that question, let me see if I can find the person. This was in the YouTube comments. Let me see. I thought I just had it here. Well, anyway, the same answer. We have to go through that 4-factor analysis, and you know, you have to think through those 4 factors and weigh the value and the cost of the possible copyright strike on your account. So I had a question from someone on the YouTube comments as well, asking me, oh, here it is. I took a patriotic song, changed the lyrics, recorded new music, sang it myself, made a performance video. So from this patriotic song, it now becomes a satire on the country's bad financial condition. Is it fair use? Same exact analysis. Yeah. Earlier this week, I had a question from a YouTube user saying, is it all right if I use the rights to a song without asking if my video is not copyrighted? Not being in all caps. And the answer is no. The song is copyrighted, and that means that only the owner, usually it's the author, the songwriter, the music company, whatever, only the owner has the right to use it or allow others to do so. So we're operating under this misconception that it's about the copyright on the new video that in which you're using the song. It's not the way it works. The video, and by the way, the video is copyrighted. You make a video today, it's copyrighted the moment you create it, unless you specifically dedicate it to the public domain, and that requires a little bit of paperwork to make that happen. No, the work is copyrighted, and you're claiming something that isn't yours, and so you don't get to use other people's stuff without their consent just because you're not making money from it, or just because you're not claiming anything other than that I made this thing. So that's not okay. Any other questions in the comments? Thank you, Danny and Genesis, everybody, for being here. It's really great to see so many people. It's nice. Let me see. Here's a question. This is an interesting, also a music question about folk songs. Thanks a million. We have a podcast, audio and video, based on the music tradition of our family here in Ireland. My wife is one of the family and grew up in the homestead of this particular brothers group that was created. They took the U.S. by storm in the 60s during the folk explosion. And the podcast is a mixture of stories and songs and music, mostly those traditional folk songs. We're concerned about copyright and how we can use this material in the podcast. It's to be heard on the standard platforms, Apple, also seen on YouTube. And before we get too far down into our new season, we just wanted to get it right from the beginning. So this is an interesting one because it brings up questions about the 2 copyrights. One copyright is the musical composition. And with folk songs, if they are old folk songs, and let's face it, not all of them are, But if they are more than 95 years old, here in the US, it's 95 years, then it's fair game to make new recordings, to use the compositions in any way that you like. That's what public domain means. The copyright is expired. But the thing is, the copyright in the musical composition, that's the work of the composers and songwriters, that may be expired. But if somebody made a recording of the song in 1979, they still own a copyright in the recording, what we call a master in the biz. And that recording, you need permission from the owner of the recording if you're going to play it in your video. So when you're doing music licensing for film and television, we always have to think about the two copyrights, the composition and the recording, and make sure that we're clearing both to make sure we have what we need. Not too many recordings are 95 years old. So they are not in the public domain, most recordings. An interesting thing is that sound recordings weren't technically protected under copyright law until here in the US, 1972. I don't know what the answer to that is in other countries. But as a practical matter, I would expect that a lot of the recordings you're planning to use are protected under copyright in one way or another. And in fact, they may be protected under what we call common law copyright, which is a state-by-state kind of protection for these kinds of things. So it is very risky to use a piece of music unless you have cleared the rights or you're doing the kind of work that would amount to fair use, parody, those kinds of things. Another question that came in was about if I wanted to do a cover of a Weird Al song that is a parody of a Nirvana song. Anyway, everybody knows what song I'm talking about. But anyway, if you want to do a cover of a parody song, you're going to use the exact same lyrics as the parody. Do you need permission from the parodist, the Weird Al, or do you need permission from Nirvana? And this is one I haven't thought very hard about. I would definitely say we need the permission from Weird Al because you're copying his lyrics, right? And his whole concept. And you're going to get labeled a knockoff artist for doing this. But if the song is a parody and that parody doesn't, it's making fun of the original and those kind of things. If the song is genuinely a parody, it's fair use of the underlying composition. So you probably don't need permission from Nirvana. But here's the wrinkle. Weird Al Yankovic typically gets permission when he does these parodies. In fact, sometimes the artists actually reach out to him and encourage him to do a parody of their song. And the reason behind that, I think, is partly he's just a classy guy. It's the way he wants to do his thing and operate his business. And he feels that it's right to share the revenues with the creators of the original work. After all, he's building on their hard original creativity in the first place. That said, if he needs that permission, if it's not really a parody, or he, whatever reason, needs that permission, then so do you. So does the creator of the cover song. And so my recommendation would be to get licenses, negotiate with everybody involved so that it's clear. Now, they may just say, whatever, just pay the Harry Fox agency. And the fact is, if you've got the Weird Al lyrics and the original Nirvana score music, you're paying half of the license to each of them. And this is what in a cover recording, it would be a mechanical license if you're selling copies. Anyway, so you would be able to divide up the royalties between those two probably equally. Again, I don't do that much work in the music arena, and this is not something that's crossed my desk, but that would be my expectation. Yeah, Genesis is talking about weird stuff is weird. So what else have I got here? Everybody wants to change lyrics. One thing I'm going to say about that, and not to put anybody down, but I think changing lyrics is a little bit of a cheap approach. Sometimes, sometimes it's funny and appropriate to poke fun by using a famous melody and changing the words. But I do think that it's a little bit of a cop out. I would rather people create something original, and original from the ground up, not built on somebody else's thing. That said, I respect parodists. I respect satirists. I like the art form, but unless it's done really, really, really well, I feel like it's just a little bit of a cop out. So, what is this one saying? I'm changing lyrics to a song from Grease, the musical. You're the one that I want, with new words about people's struggles with getting decent healthcare insurance coverage. This sounds a lot like satire. It's not making fun of the original song, it's making fun of the society. And so, again, I'd be rewriting the words, having actors act out a scenario with the healthcare reform landscape, and setting the whole thing to the music of the original song. Some videos will be funny, they will not be parodies. Is this legal or is it copyright infringement? I will not be selling them, but posting online to educate the public. The answer to that is you need permission. You got to have a license, or, I don't think it's fair use based on the same thing. If you're using the whole melody, the whole score, and just changing the lyrics, I think you're taking a big chunk, and the purpose may or may not be transformative. I mean, look, different lawyers will have different opinions about this, and that's one of the things about fair use, is that you never really know until the judge or the jury tells you whether it was fair use or not. And that means that you're maybe $100,000 into the litigation to figure that out. So not something I want to get too far into. Here's another one. I saw your video for illegal copyright. I wrote a comedy film where my character attempts to work at Disneyland as a Disney princess performer and is fired. She then tries to work on Hollywood Boulevard as a Disney princess, having pictures taken and so on. Then she decides to rob a bank wearing the Disney princess costume. And the question is, am I allowed to do this? Is there a way to do this legally? If not, here are my thoughts. I'm not imitating a Disney princess. I'm imitating the Disney performer that works at Disney wearing a Disney costume. Wouldn't this be considered a parody since it's a comedy? Okay, so we're back to this question of parody. No, it may be funny, but it's not comedy. I mean, it's not parody, because you're not making fun of the Disney princess. You're not making fun of Disney. I mean, maybe a little bit of commentary about Disney, but what you're making fun of is this person who resorts to escalating levels of unethical behavior. I don't know. So what I would suggest is, rather than making it a Disney princess, I would characterize it as a theme park princess, and don't use a costume that is readily identifiable as a Disney. So you're not going to use the Disney version of Snow White, or the Disney version of Cinderella, or the Disney version of Merida from Brave, or any of that. You're going to use a more generic princess costume, satin and chiffon and lace and a crown and a wand and those kinds of things. Great. But just don't make it a known Disney looking thing, because then you're infringing on the copyright and the design of the drawings originally from the films, as well as the wardrobe design at Disney, and also trademarks. You may be infringing on trade. You couldn't do this with Mickey Mouse for the same reason, right? Mickey Mouse robbing a bank is still Mickey Mouse, and it's going to disparage. And Mickey Mouse is interesting because it's no longer protected under copyright, right? The copyright in the Mickey Mouse character, as drawn in Steamboat Willie, expired on January 1st of 2024 after 95 years of protection, right? But it's still a trademark. It still screams Disney, right? When you see Mickey Mouse, you immediately know, oh, that's a Disney character. And so having that character robbing a bank is disparaging and dilutes the value of the brand that is Mickey, that is Disney, or that is Cinderella or Snow White or whatever. So, we'd have to do a little investigation to find out which of these characters and looks and designs have been registered as trademarks. But, even without the trademark registration, there's enough there that I would say Disney's going to have a pretty easy time taking you down a few pegs if you do this kind of thing. So go with the generic. And by the way, I think it's probably more effective as satire or comedy if it's not just about Disney. And you can look at this in film. There are examples of animated films that make fun of prior Disney characters in particular and things like that. In fact, there are characters in the movie Shrek that are drawn to look like real people who exist in the Disney company or existed in the Disney company at the time. So that you can get away with a lot, and that's what makes it funnier, is when the audience is kind of in on the joke, but you're not having to say it so overtly, right? So be smart and cute about things, and the audience will get it. They'll know who you're talking about, but the Disney's not going to be able to come after you as easily. So that's that. I think that's all the questions I've got right off the tip here. Let's see. Facebook is using a clip of a video I own. A friend pointed it out to me in an ad on Facebook. I never gave permission, and I was wondering if this could be a lawsuit in hand. Yeah. If you own the video in question, the clip, and they've used it especially for commercial purpose, but if they've used it without your permission, that's copyright infringement. Unless it's fair use, and again, with an ad, the purpose and character factor is going to weigh against them. The amount and substantiality of what was taken is going to weigh against them. If they could have licensed it from you and instead just took it without paying, that weighs against them. So it's probably not fair use. I would say, yeah, copyright infringement. If it uses, whoa, I don't know what's going on with my focus today. There we go. If it's also using a person's name, image, or likeness, maybe it's you or someone in your family or someone else. If that video is using that, well, it may also be a violation of that person's, what we call the right of publicity, which is the right of a person to control commercial use of their name, image, and likeness, or other aspects of their persona sometimes, sound of their voice in some instances. And that could also be a basis for some liability. So, I think that you want to reach out, Chris. Oops, I wasn't supposed to say your name. You want to reach out to them and demand some compensation, maybe have a lawyer help you so that they know you're serious and they don't lowball you on the payments and things like that. All right, I'm still here. I got a few people watching. Say hello in the chat if you're watching and you'd like to just let me know you're here. And if you have questions, I would love to answer. I've got a few more minutes. I'm going to go, I think, up until the top of the hour. So if there's anything to talk about. What else is going on in the industry right now? Well, I mean, Paramount Television Studios has been, it's been announced that it's being shuttered and closed down, and the productions that are already in the Paramount thing, they're moving over to CBS Studios, which is which owns Paramount, I guess. This is all in anticipation of this merger that's going on with Paramount. So a lot of folks in entertainment are going to be losing their jobs in the next few weeks or months. And my heartfelt condolences to those of you for whom that's a bad thing. Some I know are already kind of saying, "Oh, well, it's just the kick in the pants I needed to go out and do this other thing," or whatever. But nobody wants to lose their jobs suddenly and surprisingly. So there's that. What else? This is one. I hate to pick on Disney, but it's a terrible story. A physician, a doctor from Long Island, New York, and her family went to Disney World, and she did her due diligence. She's a woman who had some allergies. She's allergic to peanuts and allergic to something else, shellfish or something like that. And in the course of making their reservations and plans, they made reservations at the restaurants within the Disney World parks that provide gluten, allergy-friendly meals. and she got lists of the menus and all the things that were supposedly safe to eat. And they were having a great time right up until the moment that she realized she had been exposed to something she's allergic to. She had an anaphylactic reaction. She had an EpiPen with her. She administered it to herself. This is I think, a 40-year-old, 42-year-old woman doctor who knows this stuff. She administered the EpiPen to herself, was transported, and died later at the hospital. So her family, her husband is suing Disney on behalf of the estate and claiming wrongful death and negligence in the making and selection of the foods and whatever else. Disney's lawyers, just in the last few days, filed a motion to dismiss the case and compel arbitration of the dispute. Now, arbitration is an alternate form of dispute resolution, usually held in private, less formal than full-on litigation, no jury. It's just a judge or maybe sometimes a 3-judge panel who hear the evidence. Generally, there's less discovery, so you don't have as much access to evidence and things. But what's interesting here is the basis on which they are claiming arbitration is the right remedy is that the family, apparently agreed to arbitrate any disputes with Disney. Now, I've been to Disneyland parks. And many theme parks. Hold on one second. Gotta let the dog out. Because, the dog's never on the correct side of a closed door. So the arbitration agreement that the Disney theme park division is counting on is the arbitration clause in the agreement for the subscription to the Disney Plus streaming service. WTF. I don't get it. I don't think that when you sign up for a streaming service, you're saying, and by the way, if I go to your theme park and I get hurt, I'm going to arbitrate with you there too. I don't think that is a legitimate thing. Lawyers have this obligation. We have a bunch of obligations, ethics and things like that. But one of our ethical obligations is to our client to advocate zealously in our client's cause, right? So we're supposed to do everything we can to win for our clients, everything we can within the bounds of the law to win. So on the one hand, we have to look at this lawyer saying, okay, you came up with something interesting. You came up with an interesting approach, but there's also a duty of candor and honesty with the court and a duty of upholding the principles of the law and being an officer of the court, all of these things. And I think, this is my personal opinion, and I'll be talking more about this on my Entertainment Law Update podcast in a few weeks, but I think that this lawyer has crossed a line by taking this position for which there really isn't a lot of legal merit to this idea. I think that your contract with Disney Plus is not the same as your contract with the Disney theme park, even if they have the same parent company, right? It's sort of like saying, well, I subscribed to Disney Plus, and then I went out and I bought a comic book from Marvel. And in that comic book, I see they've drawn a caricature of me, and they're using my name, image, and likeness, and maybe even the character is made out to be some evildoer, and so now I'm feeling like they've defamed me. Do I have to arbitrate with Marvel because it's owned by Disney and I signed up for Disney Plus? I don't think so. If I go to the movies and I see something that injures me, defames me or something in a film from the Disney studios, and I've subscribed to Disney Plus, I don't think I have to arbitrate. Anyway, so this is where we are. Maybe this lawyer will be vindicated. Maybe the courts will agree that this is language that was broad enough and so on. But let's face it, when you sign up for a streaming service, these are what we call click wrap agreements, right? I don't always read every word and sometimes I see an arbitration clause and, oh, it's an arbitration clause. Okay, moving on, scroll through. Most people don't really sit down and read through those agreements. And it's one thing when it's it's what you expect the agreement to be about, the relationship with the streaming service. It's another entirely when it completely reaches beyond that into a separate kind of transactional environment where we wouldn't expect the arbitration clause to exist. Now, the other thing about this that I think is an important one is what happens when these theme park operators decide to make arbitration a condition of you buying the ticket to enter the park in the first place. And part of me is a little surprised that it wasn't already there. I'm not sure that would be enforceable either. It's what we call a contract of adhesion. You're stuck with it. And sometimes they're enforceable, sometimes they're not. So this may end up leading us into a larger nationwide discussion of reform of how broad an arbitration clause can be. There's a strong preference in the courts to enforce arbitration agreements. Maybe that needs to shift a bit. We have to put up the guardrails and draw the boundaries where we need them. So that's something to at least consider. And you know what? If this is something that gets you hot and bothered, hot and under the collar, reach out to your congressional representatives and let them know. Reach out to your state representatives and let them know, because this is how we affect change in our society. And as difficult as it is to get the current Congress to actually accomplish anything that matters, because they're so busy playing politics instead of doing what's right for our country. And that goes for both sides. I'm not taking a side here necessarily. Let's face it, they're so caught up in the game of politics that they've forgotten that they're there for the game of looking out for the American people. And so that's something that I'm going to get off my soapbox on that now. But anyway, write to your congressman. Let them know how you feel about this and that this is wrong if it goes that way. They need to do something about it. What else? Nobody else has any questions. Nothing from Danny, nothing from Genesis. I see I've still got a handful of people watching. Love to hear from you. I think on LinkedIn, I don't get to see when you comment. So I'm going to pop over to LinkedIn and just see if anybody's said anything on that platform. And where are we? Find my live here. Where are you? There we are. Click on that. Got to turn off the sound on that screen. And great. Doesn't look like there are any comments in here. So, well, I guess I'll wrap things up then, unless anybody has a last minute query for me. I will be back, let me see, next Tuesday night I'll be in Washington, D.C., getting ready to speak at the Podcast Movement Conference. And maybe I will do this live. We'll see. Let me see. 3-hour time difference means it'll be 10 p.m. Tuesday night. Yeah, maybe I'll be here. I'm going to try. Maybe it'll be a quick one. Who knows? Maybe I'll have some questions and things that I've taken away from the conference already. So tune in again next Tuesday evening, 7 p.m. Pacific time, as I do another edition of Asked and Answered Live. Entertainment Law Asked and Answered Live. And I guess that's it for me tonight. I'll say thanks for being here. Thank you for joining me and for your questions and all that kind of stuff. And let me just fix something here real quickly. And then I'm going to say thanks for watching, and I'll see you again next week. Tune in Thursday when I do my live recording of the Legit Podcast Pro podcast as well. Thursday afternoon, 4 p.m. Pacific time, 7 p.m. Eastern, when I go live. Same channels, Facebook, YouTube, LinkedIn, and I'll be talking. What is my topic this week? Let me find out before I sign off here. This week's topic for music rights for podcasters. Why music is such a headache for podcasting. And as it happens, well, that's going to be an interesting day, a historic day in the music world. So join me and find out what I'm talking about why music has to be such a headache for podcasters. And until next time, I'm Gordon Firemark, entertainment media lawyer, and I will see you when I see you.